Good morning, everyone. It's April 26, 2025. It's a beautiful day here in Las Vegas. It is super windy though, and I'm hiking a wash, so I'm hiding inside this tree right now to try to keep the wind noise down. So we had an update last night from the U.S. Ninth Circuit. I wanted to tell you about it. A little bit of a different format today. I'm not thrilled with ever being in front of this camera, but one of the reasons I'm doing what I'm doing is to shine a light on how the system is working. So in my Las Vegas federal lawsuit, now there are two, to remind everybody, there's one in Las Vegas, there's one in San Francisco. The reason there's one in San Francisco is because in order to get personal jurisdiction over some of the California government goons, I had to file a case there. This is all stemming from the fact that my kids were abducted from Las Vegas by their mother. She's admitted to the abduction in open court. That doesn't matter. We're gonna wait for this airplane to go overhead. So the fact that she's admitted to the abduction doesn't seem to matter. The family court in Santa Clara, California is the one that's exercising jurisdiction. It's doing that based on an ex parte fraud by mother's attorney, Tristan Eshelman, and a judge there named Roberta Hayashi. Essentially, Eshelman sent her a jurisdictional order in the mail, ex parte, and she signed it. And ever since then, that court's been piling on with more and more secret ex parte orders that Tristan just sends them in the mail or otherwise does what he does. I filed complaints with the presiding judge and about, for example, different versions of motions that he's been serving on me than filing with the court, and it doesn't seem to matter. Nobody wants to investigate anything. The presiding judges don't want to investigate anything. The bar doesn't want to investigate anything. Let me see if I'm still recording. It seems like it. Yeah. So the bar doesn't want to investigate anything. They do everything in secret. That's one of the problems, is they just write closeout letters and say nothing to see here, and you never get to see how the attorneys responded. You never get to see what they looked at. They refuse to take evidence. The presiding judge does the same thing. Nevada Attorney General Aaron Ford does the same thing, and so does Clark County District Attorney Steve Wolfson. And even worse, they arrested me and threw me in jail on a California warrant here in Nevada, on a California warrant that they knew had been obtained by Tristan Eshelman's ex parte frauds. So it's literally me up against everybody. The entire system doesn't want to do anything. There are no checks and balances. I'm doing what I'm doing to fight for my kids, protect myself, and to expose everything publicly. And you all make your judgments the way that you make them. I posted the Ninth Circuit decision last night on my YouTube channel where they denied my preliminary injunction motion. And for the most part, I got a bunch of support. But, you know, as always, the nasty comments come. So people telling me that I'm a loser because I don't have my kids, that I'm accomplishing nothing. You know, I just blow it off. It's not very helpful. I've never been accused of anything in the family court. I've never been accused of abusing my kids. Never been accused of being a bad father. Most of you won't know how to verify that because my California court case is secret. That's another problem I'm dealing with. The court file is even being withheld from me. So last week in the San Francisco federal case, I filed a motion for preliminary injunction asking the federal court to order the Santa Clara County Court to give me my court file, give me the same free, unfettered access that Tristan Eshelman has. He has remote access for free. I have no access. I have to go to the court in San Jose, where I don't live, and pay like 50 cents a page. And that's if the clerk is even open, because they got weird hours. So we'll see what happens with that. I gave an ultimatum to the court and to the Santa Clara County Court and to the lawyer representing the judiciary defendants in the federal civil rights lawsuit. I said, you have 14 days to give me access to my court file, and if you don't, I'm going to file a TRO in the federal court. So we'll see how that goes. Preliminary injunction appeals are immediately appealable. Now, the one that the Ninth Circuit just denied, that was on one narrow issue, which was Rooker-Feldman. The Rooker-Feldman doctrine basically says that if you have a final state court judgment for which the court had jurisdiction and you had full due process, you cannot try to do basically a de facto appeal in the United States district courts in a federal lawsuit. You have to follow the chain of courts. You have to go to the state appellate court, state Supreme Court, and then after that, the United States Supreme Court. You can't try to collaterally attack it in a lower federal court. There are many exceptions to this rule. For example, there's no rule that says you can't have concurrent federal and state litigation. This has to be on a, Rooker-Feldman has to be on a, based on a final state court judgment, not interlocutory orders. Of course, if the final state court judgment was gotten through extrinsic fraud on the court by one of the parties, or if the orders are void, then it doesn't matter. And my lower court federal judge, he got it totally wrong on my preliminary injunction appeal. He denied it solely on the basis of Rooker-Feldman, and he says that he can't review state court orders. Well, I raised all those issues. I raised extrinsic fraud, I raised void orders, lack of due process, lack of notice and opportunity to be heard, and no jurisdiction. And unfortunately, the appellate court, the Ninth Circuit, just denied it yesterday, and I'll post the link in the description. And they said that he did not abuse his discretion because I did not show that I would prevail on the 4 Winters factors. So the 4 Winters factors come from a Winters case, a case called Winters, and they are basically, you have to show that you're likely to prevail. You have to show that you're going to be inflicted with irreparable harm. You have to show that the balance of equities tips in your favors, and that issuing, I think the 4th one is issuing the preliminary injunction is in the public interest. So I addressed all those in my lower court motion. The judge, when he denied it, didn't address any of them. He denied it solely on the basis of Rooker-Feldman. So I appealed and briefed solely on the basis of Rooker-Feldman. So then the Ninth Circuit, this 3-judge panel, issues this decision yesterday. It doesn't talk about Rooker-Feldman at all, and just says that I didn't show the Winters factors and didn't say how or why. So I will be filing a petition for a rehearing in Bonk, and I will be saying you didn't address the issue and you deny me due process again. And they're going to do whatever they're going to do. Those of you who are attacking me and you know, saying that I'm wasting my time and this, that, and the other thing, this is what I've chosen to spend my time on, is by documenting this process and making it public. We all know the system's corrupt. I don't know that I'm going to prevail. I don't know that I'm going to fix it. But I'm going to go through the process. I'm going to document it. And, you know, my underlying case, I am proceeding. We're going to discovery. So I'm going to get a ton of evidence that I have not had access to. And we're going to do video depositions. And at some point, the video depositions of all these government goons are going to go up online. So that's the path that I've chosen. My point of view is that the executive branch does whatever the hell it wants, the judicial branch does whatever the hell it wants, and there are no checks and balances. And so there's no point in petitioning lawmakers. Some of you saw the comments that I made to my state senator at the beginning of the legislative session here in Nevada just a couple of weeks ago, or maybe a month ago. I got 25,000 views. It got 25,000 views, so, you know, that stuff is good for YouTube views and things like that, which again only benefit the public. They don't benefit me. YouTube demonetized me for putting up those Ninth Circuit immunity videos. They won't tell me why. They won't give me a meaningful way to appeal, and I knew that they would probably do something like that going into this. So again, I'm just fighting my fight. I'm trying to get back to my kids. I'm trying to protect myself, and I'm trying to document the process. And if you don't like it, I guess you don't like it. But everybody's going to learn what happened and what the process is like. So I think that's it for today. I don't want to make this video too long, but I wanted to try kind of a different format. I wanted to get out in the fresh air, clear my head, and tell you what I'm doing next and give you this update. So for those of you who have been supportive, thank you for the support. The comments do help. This is quite the burden. It's quite the workload. So I hope you are learning from the channel. I hope you're taking the filings and studying, and I hope you're figuring out ways to get your due process. That's it for today. Boys, I miss you. I love you. I hope I see you soon.